Speedy trial, speedy trial, speedy trial. Hey, Lee, does that law apply to me? And what about this change I'm hearing about? All right, guys, Lee, Berlin, all I do all day, every day are sex crimes and felony domestic violence cases. And here, from time to time, I get a client that'll ask, hey, Lee, this case has been dragging on a while. Does speedy trial apply to me? And for those of you that are watching right now, hey, Lee, on November 1st of 2024, I understand the law is changing as it relates to speedy trial. Does that help me? Or does that hurt me? All right, guys, we're going to go over that stuff right now, so stick around. You're going to get the answers to the new changes in the speedy trial law here in Oklahoma. Okay, so speedy trial, what is it? What does it mean? Who does it apply to? So today's video, we're mainly going to be talking about the individuals that are in custody, meaning you're sitting there in jail waiting for your day in trial. Now, speedy trial technically applies both to in custody, meaning those folks that are in jail waiting for trial, and those individuals that are out of custody. But the ones that we're really talking about today, that I think we're going to have the greatest force and effect with this change in the law, are for the in custody folks. So from a year, and it used to be a 1-year rule here in Oklahoma. So a year from when you're arrested and brought before that court on charges to when you are brought before trial. Usually it's a 1-year rule, and it's not a hard and fast rule. There are considerations that the court will take into account before they make a decision about whether or not they're going to dismiss your case or for violation of the Speedy Trial Act, or if they're going to continue the case and continue to set it for reviews. So on November 1st, the law is changing. And so if you're watching this before November 1st, the 1-year rule still applies. But after November 1st, it goes from 1 year down to 9 months. So what that means is that if you're in custody and you've not gone to trial before the 9-month mark, speedy trial will apply to you. So it's 3 months early as opposed to the 1-year rule. But this is important for the attorneys out there. If you've hired an attorney and that attorney continues time and time again to try to extend or continue or pass off dates on a particular case, whether that be for preliminary hearing or for district court arraignment, or even trying to pass a trial setting. Okay, all of those announcements, all of those waivers, all of those extensions and continuances that your attorney will be asking for or may ask for, the court is going to consider and will take into account to determine whether or not speedy trial has been adversely impacted by the decisions and the announcements that your attorney has made. Now, if your attorney's had to continue the case because of improper conduct on the part of the district attorney's office, such as discovery violations, meaning that they haven't produced certain police reports or exculpatory or inculpatory evidence that's going to exonerate you or incriminate you. So if you have those kinds of issues and those problems, and it's not because of any intentional delay on your part or on the part of the attorney, well, you're still eligible for relief under the Speedy Trial Act. But there's a whole bunch of stuff that the court will consider when your attorney makes that application to have the case dismissed for a violation of the Speedy Trial law. Now, if the court were to say, hey, because of the way that our current docket is, or due to some other type of extension or extenuating circumstances, we're not going to dismiss the case at the 9-month mark, but we're going to continue to set it for periodic reviews, which is what we see happen a good deal of the time, because it's not the court's fault, it's not the DA's fault, and it's not the attorney's fault that's representing you that causes this delay. It's a system problem. It's not a malfeasance problem. It's not somebody acting in bad faith type of an issue. Well, then what the court used to do is set this thing for review, your case for review, every 4 months to see where it is in the pecking order and whether or not relief should be granted to you, such as a dismissal. Now that will change as of November 1st from 4 months to every 3 months for that review, in an effort, again, to get your case moving or get it dismissed. Now, the practical effect of this has district attorneys' offices all across this state and judges all across the state going, what the heck are we going to do? Because we have a lot of cases set for trial, not enough judges and not enough trial weeks. And that's going to result in a lot of cases getting dismissed. and a lot of appellate work when some of these judges are not dismissing because of some BS made up reason of why they're not going to dismiss the case for violation of your speedy trial rights. That's going to cause even more litigation before the Court of Criminal Appeals. And so I don't think this issue is done yet. I think that there's a lot that's going to take place at the Court of Criminal Appeals. It's going to help sort this out and get some additional clarity as far as what types of cases are best suited for relief under that Speedy Trial Act, and what kinds of things do we as defense attorneys representing good clients that are getting screwed by not getting to trial fast enough, what are the things that we need to avoid, and what are the best practices for us? So if you think that you have one of these issues, reach out to your attorney. If your attorney's not responsive and you think now might be a good time to explore substitute counsel, pick up the phone, set that initial strategy session. Now, if you're not ready to do that yet, if you're not really certain if you need to change horses in midstream, I'd encourage you to go ahead and download some of our great consumer guides. If you've never hired an attorney before, or you've hired only one, and that current attorney, you're not really sure if you've got the right guy or gal for the job, why don't we go ahead and download this consumer guide and see what are those 8 foundational questions that I absolutely positively must ask an attorney to know whether I've got the right guy or gal for the job. All right, guys, this is Lee Berlin. All I do is help guys like you stay the hell out of prison. Till the next one.